Huh, what's this? Wait, this is the Ninth Circuit's ruling. They gutted Walker's ruling like a fish. I mean, like, they like reached into the fish belly and just, yeah, blah, threw it all over the place. I mean, yeah, I'm glad that Prop 8's, been declared unconstitutional, but did they have to, like, do that? Did they have to do that? I feel that the Prop 8 case, that the Ninth Circuit did an awesome job. Judge Vaughn Walker's ruling was sweeping, and it was really good. It even said that Prop 8 can't pass rational basis scrutiny, which is the lowest level of scrutiny that you have to meet in order to save a law, and to save a law's constitutionality. Over that 13-day trial, which is Eight, the play by Dustin Lance Black, who got a lot of the court transcripts, which are awesome. They're really great. I've read through like the first 4 days, and it's really cool. But the ruling, that Judge Vaughn Walker's ruling, was amazing. And if you haven't read it, you need to read it. That is one piece, I think. Some people say, hey, do they teach you gay kids any, like, gay history? I really wish they did. But if there is a gay history curriculum, I want that ruling to be in there. That should be required reading for everybody. But over that 13-day trial in January, and then the August 4, 2010 ruling, it was amazing because it was findings of fact, conclusions of law, and he really, those 12 days of testimony, I'm sure he had to, like, listen to it over and over and over and over as he prepared his ruling. Now, in the meantime, after the ruling was done, they tried, the NOM and Protect Marriage California tried to get it, or protectmarriage.org tried to get that ruling vacated because of the gay judge. Judge Ware, who took over Chief Judge Walker's district court seat after Walker retired, said no, this is not true. Then that would mean that black judges can't hear any cases of discrimination against black individuals. Alabama was a case that had something like that, where they did not recuse a black judge because they, I think the judge's kids were maybe going to a school or something like that. But actually, I don't think the judge's kids, or I don't think the judge had anybody who was a party to that. He was just black, so they didn't, or he or she, judges can be women, that judge was not held to recusal. So that's a little bit of background in the meantime and whatnot. But and then of course the tapes, they wanted to hide the tapes so they could hide how bad they lost. But the Ninth Circuit Court, what I think what they did was pretty cool, because it was also unique to California, and as far as the situation with California, but it could happen anywhere, just like it's happening in Maryland, just like it's happening in Washington, just like it could easily happen in maybe Arizona. Let's say if they struck down their constitutional ban there, and they could petition the ballot. In many states, where you can petition the ballot, they've already passed. Like Nevada's one of them, where Lambda Legal's challenging theirs. Illinois, their Lambda Legal is pushing ahead with a case there, but the citizens of Illinois cannot directly amend their state constitution. I think they have to give it to the General Assembly as a question, and then something happens there. Delaware, actually, you can't petition the ballot there for constitutional amendment. The legislature does, which is interesting because I think that's left over from the days when Maryland controlled Delaware, which is interesting. But anyway, I completely digressed on that. But where you can, and where they had referendums to put it on the ballot, like in Louisiana, Mississippi, Montana, or Montana was a ballot initiative 96. Amendment 3 in Arkansas, where it was passed down to the people in 2004 after Massachusetts got theirs. The whole thing is, it works within the frame of California's situation, but it could happen in many places, like, as I said, Montana with ballot initiative 96, where it was passed to the people, but it was petitioned for the ballot. Like, you can't they said basically you can't take away a new right because it's new. Amendment 2 in 1992 did the same thing, but with sexual orientation protections. It basically said that because we don't like this, we can go ahead and petition the ballot and say there's no sexual orientation protections, period. So what they ended up saying was, hey, we don't like the fact that Aspen, Boulder, and Denver have passed these laws, or these laws stating that no discrimination based on sexual orientation. So therefore, what we're going to do is we're going to petition the ballot, and we're going to override that, which is what Proposition 8 also did. We're going to override that by saying no sexual orientation protections, no state, local, county, anything. No municipality within the borders of Colorado can enact or blah, 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 blah. In other words, put into effect any protections based on sexual orientation. No court can step in and declare relief. No act of the legislature, no act of the governor, because there was an executive order in one of them that prohibited government discrimination, or government workers from being discriminated against. So many people could have easily lost their jobs, their homes. They could have easily lost so much because they're gay. And sexual orientation also means straight, but a lot of times there's hardly any discrimination against straight people by society. But they took it to court. It was struck down in 1996 in Romer versus Evans. Governor Romer of Colorado was opposed to it, but Evans may have been the Attorney General, and that's probably why it's Romer versus Evans. But what ended up happening was that they said that the Supreme Court said that this is unlike any law that we've ever seen. Like, this is an unprecedented law, and to allow this to pass constitutional muster would be just, we have never heard of this before. Like, it would be an anomaly of jurisprudence. I'm paraphrasing that. So, enter Ninth Circuit, rather, and they say, hey, Proposition 8 is unconstitutional, but they don't say there's a right to marry. They do say that you can't take away new rights because they're new. Washington and Maryland. Maryland is not covered under the Ninth Circuit Court's ruling, but Washington is, and that would be a good precedent if it were to go to federal court in Washington. The state court upheld mini DOMA in 2006. They passed it in 1998. 2006, the Supreme Court upheld it in Anderson versus King County. You can also look at that too. Really pissed me off whenever I read it, but because it's the same old stuff that I've heard every day. That, well, anyway. So the reason why I like what they did was because they allowed a situation to occur where this precedent could be invoked. They could also say, listen, this was a newly recognized right, and they just can't take it away because it's new. They've also set up, even though they didn't say there's a right to marry, they said the right to use the term, the designated term of marriage. I think I like that. No, I do. Simply, well, I do. But I like that because of the fact that, that they didn't exactly say the right to marry, but they did say the right to use the term marriage. So it's kind of a little sneaky way under the fence, but they really were able to kind of stuff that in there. They didn't gut the ruling. I would disagree with anyone that says they gutted the ruling. But they added a dimension that was already there. That was California's situation. That could be that they could easily say, hey, this is what happened. Perry versus Brown, by this time it's Perry versus Brown, said that you cannot do this. Prop 8's unconstitutional, so is this amendment. And, that really gives us something to work with. Because Amendment 2 did the very same thing. It was animus. And you can prove it, and they proved it in the case, that it was just animus. So that's how I feel a bit about that. That they actually did a service to Von Walker's ruling, even though it wasn't as sweeping as Von Walker's ruling. Which I feel that Von Walker's ruling will definitely be one of those things that will be required reading for law students, if not already. And so will Perry versus Brown, because those are two cases, or Perry versus Schwarzenegger, Perry versus Brown. That's one case, you know. But of course, it changed when Governor Brown was sworn in as governor of California, and it really is amazing that a federal court has now said that we have the right to use the term marriage, because people understand marriage, they don't understand civil unions, and which is why I'm glad about the lawsuit in Illinois and Nevada. I'll really definitely be watching those. I'm also watching the repeal effort in Ohio. I don't know if more than likely the day probably passed, but I wonder if they got enough signatures. They probably, I don't know. I hope that they qualify for the 2013 ballot. It very well may be defeated, but that's a starting point. Whenever our ballot measures to extend our rights are defeated, whenever marriage bans are passed, no matter how it turns out, it's always an opportunity for us. So, this is VidHead 85. I'll see you later.